Good morning, everybody. Welcome to our second panel with the snappy title of Too Much of a Good Thing. Our case is becoming overmanaged. Now, it's no longer 9 o'clock. We're the second panel, so hopefully people have woken up a bit. And we're keen to have an interactive discussion focusing on the many and varied case management developments that there have been over the last few years, and particularly keen on hearing war stories, preferably humorous ones, both good and bad, about people's experiences. Now, I've got a stellar panel here. I'm sure you've read all their biographies in the pamphlets, but just briefly to my left, I have Henry Byam Cook, who is a silk from 20 Essex, who specialises in international commercial disputes, and frequently those with a large technical dimension. To my right is my other colleague from 20 Essex, Daniel Boven-Ziepen, and there's a bit of a theme here. He too specialises in international commercial disputes, and has appeared before a very wide variety of courts for somebody of his call, including the Court of Appeal and the Supreme Court on at least one occasion. I'm not sure if it was one or two.
Supreme Court once.
Supreme Court only once. Well, never mind. I'm sure I'll be there again soon. And then on my far right, I have John McElroy, who's a partner from Hausfeld, who specialises in complex and other high-value commercial litigation and arbitration, with a particular emphasis on financial matters. Now, you may note that there's only 4 of us, and we are missing Natalie. Sadly, Natalie has been unable to join us today, which is a great shame. But we will, nevertheless, we are going to soldier on, and hopefully we will be able to cover the parts that she was meant to be covering as well. Now, we're going to kick off with disclosure, given that, so we're going to focus on 3 matters, I think, today, which is disclosure, cost budgeting, that favourite one, and also the recently developed witness statement reforms. We're going to kick off with disclosure, and with Daniel on this. And Daniel, I'd like to begin by asking you, on balance, how do you think that the new disclosure rules, which have now been the pilot, which has now been in place for some time now, how do you think it's working? And could you highlight what you think the most significant features are and your views on them?
Well, thanks very much, Sarah. I think the bottom line is that the intention behind the rules is a good one. The reality in practice, I think, is that whilst in some respects it does work very well, I think a lot of people will have experienced at the coalface that actually perhaps the demands imposed are even more than the framers of the rules and the courts perhaps envisaged, and that actually the impact in practice has been a very significant amount of work in preparation, particularly for case management conferences, and also therefore the scope of case management conference hearings, and that in turn obviously has an associated cost consequence. And in particular, that there's a very heavy burden on the parties now in connection with disclosure in completing the disclosure review document, which I think on first sight for many of us was quite a horrifying document when you looked at the length and complexity of it, and took on board the need to start talking about that and engaging about that with the other side at a very advanced stage in advance of the CMC. And in particular, obviously, that has a consequence not only in terms of increasing costs, but increasing costs at an early stage of the case. So it's the front loading of costs, which I think can be a real bugbear for users. And if I was to pick out, because we could talk about this really all day and beyond, but one particular feature of the disclosure review document and the process, which gives rise, in my experience, to a very heavy burden, it's in relation to disclosure models, and in particular, narrowing in more, I would say in my experience that disclosure model C has quite a lot to answer for in terms of the burden. And actually, there have been some recent reforms, very recent, in fact, so it's quite topical today to be talking about this, which I would like to touch on. But before I do, just to highlight, I think for me, sort of three aspects of Model C, which can give rise to a high burden and some difficulty. The first of those is just the fact that when you're formulating and debating Model C disclosure requests, Model C obviously being the snappily titled request-led search-based disclosure, you have to approach that by completing section 1B of the DRD, and both sides, obviously, everyone will be familiar, I think, now with completing that section and exchanging proposals in relation to requests. Now, the intention, and it is very clear in the rules, to be fair to them, in paragraph 8.3 of Practice Direction 51U, is to confine requests either to particular documents or at most narrow classes of documents. But without wishing to tar all lawyers with the same brush, and not infrequently, I think, battle-hardened litigators can't resist the temptation of drafting requests, at least at the outset, sort of starting high in the negotiation, in a sweepingly wide way along the lines of any and all documents relating to a particular topic, and then in time-honoured fashion with a liberal sprinkling of including but not limited to, followed by a long list of subcategories of documents. And I think, looking at one or two faces, others in the audience may have seen that being done, even if it's quite obviously contrary to the intention of the rules. And I think it's not only deprecated by the rules, but also there are some quite insightful comments, I think, of Mr. Justice Baker in a case called PIPIA and PGEO Group, where he explains quite clearly the intention, at least, behind Model C, and deprecates some parties' approaches to that.
Can I just jump in there? And John, I just wondered if you've had any experience of the Model C disclosure model, and what you think about this requirement, which seems to me to be quite similar to Redfern schedules, the idea in the IBA rules that you have to specify your documents very precisely. I mean, I suppose the contrary argument could be, well, the problem is if you go in too precisely, you're quite likely to miss things. And how do you know what precise documents the other side has, particularly at the early stage in the litigation?
Yeah, well, I think the reality is that Model C is used more infrequently than the working group had planned originally. Where I think it does work quite well from experience has been when you have quantum documents, because rather than going in and using keyword searches and having to search among possibly thousands or more than that of emails for quantum documents, you can actually search within the financial system and agree that at the outset. But I think ultimately my experience has been that with that exception, Model C is not used.
Henry, is there anything you'd like to add?
Well, I don't want to be the advocate of Model C, but it is there because of the underlying thrust of this and many of the court's reforms. The court is concerned, I think, about litigation becoming ever more expensive. And there are, I suppose, two schools of thoughts how to solve that. Do you try and crack down, which is what the court has done by trying to impose a framework? And really, I think it's trying to, through these reforms, instigate a cultural shift in the approach of parties to commercial litigation. Disclosure had been seen as being the area of ever greater expense, and that goes hand in hand with the fact that documentary records are a more and more prevalent part of business transaction and daily life. I mean, even at the time of the Wolf reforms, instant messaging and other social media platforms for communication didn't feature that prominently, so that the scope for having to go through wider and wider areas has exploded. And I think it's right that the court should make people think more carefully, a more targeted fashion, rather than saying, well, there will be a standard disclosure, we'll load up everything and anything, and then conduct a wide-ranging disclosure review against the pleadings or some sort of less well-defined issue structure, which I think will lead to huge volumes of ultimately irrelevant documents coming before the parties, even if ultimately they don't go into the trial bundles.
What if the parties themselves, I mean, say, on turning to the theme of our session, What if the parties themselves want a very wide disclosure exercise? I mean, have you found, Daniel, that the judges are prepared to go along, or the judges jumping in and saying, well, you may want this, but we know better than you what's good for you?
I think in my experience, it depends very much actually on practical considerations as to how long you actually have by the time you get to a CMC and whether the parties are really fighting about it. But one of the things I've noticed, I think, is that very often there's a sort of long drawn out negotiation in relation to aspects of disclosure models in the disclosure review document, which very often doesn't reach a culmination until a day or two before the case management conference. And therefore, you're also in difficulty in identifying the scope of any dispute and therefore how long you might need the listing to be for. And the reality, therefore, is that you quite often, I think, get close to a case management conference and everybody panics and thinks, well, we don't have time to debate this. So everybody's much more in the mood for compromise than the day or two before because of the risk of not being able to properly ventilate some aspect in dispute in front of the judges. And then beyond that, I think that it very much depends on which judge you're in front of, and therefore it can be quite unpredictable. Some judges are much more interventionist than others in reality, and it depends on what particularly attracts their attention. But I mean, when it comes to something like Model C, I would say as well that sometimes, depending on the degree of complexity, the judge really needs to have a very in-depth understanding of the case in order to properly engage with that. And the practical realities are sometimes such that the judge doesn't necessarily have sufficient reading time to get into the case to that degree as well. So it's a question, I think, of pragmatism as well in the face of
I'm quite interested actually on Henry, what you think about that, because I certainly it's something that I've come across with disclosure, which is you've got, in order quite often for a judge to decide on disputed disclosure, they need to have a deep understanding of the case. They may have 4 or 5 cases in the commercial court on a Friday and limited time to do the reading, and the hearing is also limited. How is it best, do you think, to approach that when you're actually doing the advocacy?
Well, I have to say my general experience has been in the main that judges will engage, and if inevitably there is going to be narrowing of issues. It's a process, and that's why the process and the rules anticipate you starting quite a long way out. So yes, there might be a bit of a panic as you come towards it, but ultimately I would say to anyone in all of these situations, if you're starting out with your correspondence, don't take positions that you wouldn't be prepared to have articulated on your behalf in front of a judge. I mean, it's not quite the red face test, but there's no point taking an ultra-aggressive stance 12 weeks out, knowing that you're never going to actually adopt that. There is a strong ethos of cooperation the court expects, and I have had experience of judges who get frustrated, and they will not hold back from expressing that frustration that parties have drawn out what should be a much easier process and been far too antagonistic about it. But in the main, they have rolled up their sleeves, in my experience, and that is just going to be a question of articulating it in the skeleton, if you can explain why that formulation works and the other side doesn't quite capture the essence of the issue. And I have generally found that the courts are going to then look at the pleadings. They'll say, right, so you say this is the issue, take me to the paragraphs of the particulars of claim, the defence and the reply, so I can see where that tracks through. And if you're unable to defend it by that analysis, they will go against you, because it's got to have that footing in what the parties have articulated the actual issues are.
Daniel, you were going to tell us something about the reforms which are just hot off the press.
Yes, well, interestingly, there has been a revision which is in operation as of the 1st of November to Practice Direction 51U. And they're not very extensive changes, but perhaps one of the main ones, topically in connection with Model C, is to introduce something that they're calling the less complex claims regime, which is now in a new Appendix 5 of Practice Direction 51U. And broadly speaking, that's a more streamlined procedure for less complex claims, which is not specifically defined, but parties can seemingly agree that something is a less complex claim and therefore opt into it.
But there are no guidelines for it.
But equally, not Well, there are guidance notes in the appendix, but I don't. There's not, I don't think, really any very specific guidance as to how you identify precisely what is a less complex claim. And it does appear, at least on my reading of the rules, that you can agree that it's a less complex claim. Now, it's going to be an interesting question as to whether or not judges will step in then and say, where parties look as though they're just wanting to effectively opt out of the full rigour of the rules in a relatively complicated case, that the courts say, no, you can't agree to do that. We're going to actually impose the full rigour of the full disclosure review document, because accompanying the scheme is a more streamlined disclosure review document. And one of the interesting features of it is that in this regime, Model C and Model E are out, just completely out. So that there's no question of having to have a debate about Model C. And I do wonder if it is the experience, particularly in some cases where it may be disproportionate to have a costly and sort of long drawn out debate between the parties about the use of Model C, that has prompted that change. And a sort of related facet, I think, with Model C that has struck me before is that, as Henry very much says, it's about parties operating this sensibly and thinking carefully about which model is suitable. But I think that also includes not assuming that there's necessarily an automatic hierarchy between Model C and Model D, for example. I find in practice very often people approach it on the assumption that Model C is definitely narrower disclosure than Model D. But of course, that all depends on how you frame the Model C requests. And also, I think, depends on what the alternative under Model D would be, depending on the issue. Because if you get into the nitty-gritty of what keyword searches and other electronic disclosure filtering techniques you have, you may be able to arrive, I think, at actually a narrower, more focused disclosure under Model D than Model C. It all really depends. And so maybe the parties need steering a little bit more as to how they choose between the different models. And in some cases, the courts have obviously decided that the complexity is disproportionate to the cost and that we're going to have the simplified regime where Model C goes out the window.
John, can I just ask you, how do you think clients are going to receive the prospects of being told that their claims are less complex and therefore subject to a different procedure?
Yeah, well, I think what clients are after is engagement between the parties as well. So I think if we can get an improvement on that and not have, as Henry was saying, in the run-up to at the CMC, some panic where suddenly parties have adopted these very different approaches to the DRD and then coming together at the last minute to avoid having a prolonged fight at the CMC. I think that's a good thing. But equally, I think in managing how you express that as a non-complex case when it is their case and they're very concerned about it and wanting to pursue it is going to be a case of managing expectations, really.
Thank you. Just before we leave disclosure, I'm interested in your comment. Any comments that that the three of you may have on disclosure guidance hearings? Because my understanding is that they were an innovation that were introduced that perhaps has not been as popular as people thought it would be. Do you want to kick off, Daniel?
Yeah, thanks, Sarah. I think that's certainly right that I actually haven't had any experience of disclosure guidance hearings, and I've not really heard many people advocate for them, and the courts have, I think, commented on there being relatively few instances of that being taken up. And that is actually another small change that has recently been implemented in the latest practice update to the changes effectively to emphasize that a disclosure guidance regime doesn't have to involve a hearing. It could just involve the parties effectively putting in writing before the court what issue it is they want some guidance on, and the court on paper giving them that guidance. And it may be that encourages people to use it a little bit more. I think that from my experience, the real issue has been, having gone through the pain and expense of a case management conference, nobody's very enthusiastic unless absolutely necessary of going back to the court and incurring yet more cost in getting further guidance. They'd rather find a way to resolve it between them or get it all in front of the court at the first case management conference. And I think the other aspect is the guidance is effectively, in the usual case, only a 30-minute hearing. And I think, ironically, in situations where you really need the court's guidance, probably a lot of people are thinking 30 minutes isn't enough. and they don't want to be met with a court that's reluctant to grant them the time necessary to actually ventilate whatever issue it is. So I think a combination of reasons has meant that it's just not been popular so far.
John and Henry, has that been your experience, or have either of you had any experience of them?
I haven't had one. I haven't been in a case where it's been thought necessary, but the area, I think, it's not necessarily just targeted at this area, but where the rules probably engender the greatest complexity is multi-party litigation, and I think that's another area. It's not so much a reform, there are just new paragraphs added as of last week to the pilot to deal with multi-party cases, effectively admitting that the disclosure regime out of the box isn't necessarily that well suited to multi-party litigation, and inviting the parties to engage with each other and with the court from an early stage to have a bespoke regime. So in some ways, I'm not sure I'd call this an admission of defeat, but it's a sort of case management without an answer. We want you to be managing it. We can't tell you quite how to do it, but come and see us. And that's maybe going to work in a monster case where you might have a designated judge from an early stage. They can handle the litigation. They can fine-tune how the process is going to be worked. But there is, as we all know, a huge range between, to be honest, the less complex claims is not going to be something we can get into for most commercial litigation. It's a sort of, I see it more as an area where if it's the shorter trial scheme might be on your radar, that's where you're talking about for less complex cases. But for the whole range in between, the disclosure guidance hearing, I wouldn't talk of it as a tactical weapon, but compared to writing 12 letters backwards and forwards and having extended internal debates, just cut the Gordian knot, put it in front of someone. And again, you can force someone into the red-faced situation. If they're not prepared to have the court see the stance they're taking at an early stage, make them have to justify that.
So you would say something that we should be looking at using more?
Yes, definitely.
Yes. Yeah, engage the judges. Very good. Next, cost budgeting. Now, cost budgeting has been with us for some time. There are many varied views as to whether or not it's a good thing, a bad thing, or a very bad thing. We're going to deal with it briefly today, and I'm just going to pose two questions to the panel, two questions of general principle. And the first one is party autonomy. If the parties don't want cost budgeting, should the courts be imposing them? John, would you like to kick off on that?
Yeah, well, I guess it comes back to the whole, our case has been becoming overmanaged. And the answer to that is that I think there's a good reason to have the rule there, because without the rule, you'll never have cost budgeting. And in some cases, it does work. I think the flip side of that, though, is that, and we were discussing this in advance of the session, how many of us have actually had cost budgeted cases actually go through where the cost budget has come into play at the very end? And the answer to that, certainly from this panel, has been very limited experience of that. So it's a very significant expense at the outset for little to begin at the end. And there is a question as to whether that is therefore a good use of time, because I think that the reality is it's not as simple as a cost draftsman doing the work and you submitting it. There's a lot of work goes into preparing that cost budget to get it right in the first place.
Daniel?
Yeah, I mean, I very much agree with John. I think, again, it's one of those aspects of the rules where perhaps the framers of the rules underestimated quite how expensive the budgeting process would be. It's obviously not as major an expense compared to some other phases of the litigation, but it's sometimes not insignificant, and parties are not always enthusiastic about having budgeting in place. I think one sort of feature of the rules at the moment that I would pick out is that we may be in a sort of no man's land as to what the objective is to some extent. In this sense, is that if the intention is to actually force the parties, even where they would rather not have budgeting, to stick to a budget, then do the rules need to go further than they currently do? Because at the moment, if the parties do agree cost budgets, then the court has much more limited powers to intervene. What it can't directly do is sort of overrule and impose a different budget at a case management conference. They have a sort of tool of softer measures that they can do to encourage the parties to a different budget, but not actually impose one. And that, in turn, can incentivise parties, I think, who don't really want a budget and there's agreement on both sides, to just inflate their budgets at the outset. And therefore, in practical reality, quite often where there may be other issues in dispute at a CMC, judges, in my experience, don't always then look into cost budgets where the parties have agreed them, even where the headline figures may be somewhat inflated. And so to that extent, I think thinking about that aspect of the rules in particular, it reopens which direction do we want to go in? Do we want to say, actually, in cases like that, and there may be fraud cases, for example, or cases where personal reputations are at stake, where there are reasons beyond the purely commercial as to why parties might want a bigger budget to fight this, they should be allowed to then agree, party autonomy, as Sarah says, that they just don't want the cost budgeting regime. Or if we're going all in and we say no matter what, the parties have to have it, then do the courts need more in their sort of toolkit to actually intervene and overrule parties on budgets, even where they've agreed them?
Henry, just picking up on that last point that Daniel made, in your experience, do parties care about cost budgets in the sense that do they always follow them, or because at the end of the day they only limit recovery, they don't limit what you can charge?
Well, quite. I think that's an unseen part of this debate. I mean, I think again, I'm going to be the advocate on the other side of the debate here. In some ways asking the question, well, should parties have to have them when they both agree they don't want them? That's to focus on probably what would be the narrowest class of circumstances where the budgeting question is going to arise, because what passive budgeting does do is it gives upfront transparency, and I think it is a very great, a quite well-targeted tool towards the furthering of the overriding objective. You can have proportionality imposed by the court in terms of, well, you can leave every stone unturned if you choose to, but you're not going to be able to lay that at your litigation opponent's door. And if you have, as the party who might be feeling oppressed by the gargantuan legal forces being deployed against you, having a cost budgetary control takes away a oppressive aspect of litigation that had been deployed in the past.
Good. Now, for the last part of this session, we're going to talk about the most recent development, which is the new rules on witness statements, which have been enforced, I think, for about 7 months now. And I'm going to ask John to kick off with those and his recent experiences.
Yes. So I guess just to start off, in this room, how many people have been through the new practice direction on witness statements?
And survived.
And how many, with the hands up, have enjoyed the experience or thought it was a good experience? Right. So that's probably consistent with my view on it. So I think in short, this practice direction has been in place since the 6th of April this year, as Sarah said. It was very much led by the judiciary looking at witness statements and having concerns about there being too much argument in the witness evidence put before the court. So they were keen to review it, and this resulted in this practice direction. The two key changes in the practice direction, as I see it, are one in relation to documents, and which is a main one and has various themes to it, and the second one in relation to compliance. So obviously in relation to the documents, now you have to, in your witness statement, list out all the documents that your witnesses have looked at in preparing that statement. The purpose of that to result in a transparency in relation to what the witness has needed in order to refresh their memory and to give evidence. This obviously was a pretty controversial aspect of the work within the working group. I think, and it's quite equally split down the middle between the judiciary and the solicitor group on the working group. And really what is looked for now is the witnesses to deal with what is called important disputed matters of fact. And it has to set out what that witness's recollection is. So how good is that recollection, and when and if it was refreshed?
Can I just ask you, John, practically, how do you do that? So when you do do you say, I have a strong recollection, or I only remember the colour of the walls and the coffee we had, or what? How do you do it?
This is the fundamental issue with it, because you have witnesses who, often you're doing this 4 or 5 years after the event, witnesses, a variation within them of witnesses who have been involved in identifying the case in the first place, so have looked at a lot of documents, and others who really haven't looked at anything since And one of the challenges is you ask them for the best recollection of events, as we're required to do, but then you know, because we've been through the disclosure exercise, that actually that recollection may not match the documents. And then you end up in a position whereby, I guess is what the judiciary was after, is that you are then relying on the documents and not the witness's evidence of it. But I think, as Henry will come on to, that gives a challenge at trial, because witnesses can be cross-examined on their recollection of events, even recollection of events that will not be necessarily spelt out in the witness statements. Mm-hmm. So practically, it's a very difficult challenge, and has been, certainly from my experience, an expensive challenge from the client's perspective, because it as we are all learning these new rules and how to apply them, you have to sort of very carefully manage that. And also listing out the documents in itself is a challenge, because and inevitably, and certainly in the witness statements that I have seen, there is this opening paragraph which says, these are the documents I have seen in reviewing the witness statement, but obviously I have been involved in this litigation for 2 or 3 years, and I have looked at other documents which may not be listed in here.
And in terms then of cross-examination, Henry, I don't know if you've got any views on this. How do you see that the list of documents is going to become quite central in how you cross-examine witnesses?
Yes, in short. And then what I would recommend, and this may be unfair because you probably have all done this, but anyone who's looking at the practice direction and the scheme should also read the 2 working group reports from about 18 months out and 6 months before the implementation, because you get a lot more flavour as to what the rationale is behind some of the provisions by reading those working group reports. And so if we come to this point about list of documents, this was highly controversial. The thinking of it is that if we start with witness statement is your witness's evidence in chief, the courts were trying to think back to, well, what is the process for giving evidence in chief back in the pre-Wolfian era? What documents could an advocate show a witness in chief legitimately to refresh their memory? And it's touched on in the statement of best practice, but effectively, if it's a document the witness authored or saw close in time when the recollection of events was fresh in their mind, that's a legitimate tool to refresh their memory. If you find that you're showing a witness a whole sequence of emails between parties that they weren't seeing at the time, that then is an illegitimate evidence-in-chief tactic. And what we'll see is, as scrutiny of witness statements and lists of documents, one of the things we'll be focusing on, well, has the witness been looking at what effectively would be illegitimate evidence-in-chief documents to refresh their memory? And that, in turn, I think will then be a route into challenging the credibility or weight to be given to any recollection that witness is purporting to have about the events in question. Where I foresee difficult borderlines is that the rules require statements as to how the witness statement has been prepared. John has mentioned already that the depth of the recollection of the witness. Where is the borderline going to be drawn in the privilege of the witness statement taking process as to where questioning is able to be directed? Can you seek to expand? If the witness says, I prepared this by a sequence of interviews with my solicitors, can you as an advocate seek to press about that detail, given that the statement of best practice, you could ask questions as to the degree of compliance with that statement of best practice. And so certainly going to open up an area. It's not going to be that edifying to be the sole basis of your cross-examination, but it's going to open up a practical level of attack towards a witness rather than just saying, well, you don't really remember, do you?
Now, compliance, John, just picking up on what Henry was saying, the stick side rather than the carrot. How's that going to work?
Yeah, so the compliance is really about making sure the witness understands that the rules have been complied with themselves, as well as the solicitors and the solicitor with responsibility for the overall drafting of the exercise to sign up to it as well. I think that obviously comes with sanctions for, as you would expect, for not complying with and not doing it in the right way. I think that has provided some nervousness for clients. Because obviously they're guided by us and it requires reassurance. But obviously it is a good thing to have some kind of compliance and requirement to sign off on things to make sure people are doing it the right way. So there is some accountability to it. And in short, I guess for most of us in this room, I would like to think that was probably what we did under the old rules in any event, making sure that people were only putting into evidence what was their best recollection of events and was an honest picture of the position. So I think in that circumstance, the compliance, I certainly don't object to the compliance, and I think if it makes us all comply with the rules, that's a good thing to see if they can get them to work.
The next area that I was going to ask about was if we are limiting witness statements to personal recollections and disputed issues of fact, how are we going to deal with the narrative? How is a party going to get its case theory across to the judge, and how's that going to work? John, would you like to kick off on that?
Yeah, and I think having been through the process, there's this: you generally get to the witness statement stage, you have really from both sides the story, the narrative and what the judge is going to read in the reading day or a week before the trial starts. But actually, what you're seeing from the witness statements, they're dealing with specific points. It's not the story that we're all used to. So I do think that they will become, I think what we're going to end up is with opening skeleton arguments, which are much longer and much more detailed, because that is going to be the first time when the disclosure and the witness evidence is pieced together into the story. And that, from an ADR perspective, is not necessarily a good thing, because actually it's the first time that the clients on the other side will understand the story and see it written down. I think that's going to be a challenge that we're going to have to deal with. I know there's been some discussions about having some kind of joint statement of facts from the parties, although I am not optimistic about parties being able to agree a joint statement of facts.
Well, presumably it's almost the antithesis of the narrative, given the narrative tends to be subjective.
Yeah, and we all know how difficult it is to agree a case memo or a list of issues, never mind a joint statement of facts for the trial. So I think we're only 7 months in. For those of us who have been through it, we're probably all hoping we're not the first one to go through a trial on it, and be the one that's going to be subjected to one of the judges who's going to be particularly focused on making sure we're all doing the right thing by these rules.
Daniel, how do you think people are going to deal with the narrative? Because presumably the page limits for skeleton arguments are still the same, aren't they? And the days when we used to put everything in size 10 font and get shouted at because the judges can't read it are gone.
Yeah, I think it's going to be quite difficult. My suspicion is that a lot more weight is going to be put on chronologies, actually. In part, I think, because the courts have in mind that they're going to steer people towards chronologies as being the useful vehicle for setting out this sort of narrative. And the parties can therefore sort of pay lip service to compliance with that. But to the extent that you want to get in the more argumentative aspects of your case, you obviously can't be forced to agree a chronology, and therefore there might be, again, another sort of long, drawn-out negotiation in relation to chronologies, and more instances where actually chronologies are not agreed because parties see that as the vehicle, potentially, for setting out their rival cases and getting across to the judge certain things that they want to emphasise or certain complexions that they put on the facts. Interestingly, I think there was a practice direction from around June earlier this year in relation to hearings up to 5 days in length, in which the standard direction, the commercial court, is intended to be no pre-trial review, but quite detailed regime in terms of agreeing and serving quite far out in advance of a hearing, chronologies, and pre-reading lists for the judge, so somewhat further in advance, and a slightly more prescriptive regime for doing that, and it involves doing it sequentially as well. So I think, for example, that procedure might give rise to situations in which one party puts forwards a chronology and then you follow sequentially, the other side puts it forwards, and then if there's no agreement, you may end up with rival chronologies being the vehicle for submissions in the case, in effect.
Henry, so potentially more paper and more cost. Would you like to comment on?
Well, yes. I mean, going back to our theme, too much of a good thing, are they becoming overmanaged? I see this as a highly managed set of reforms on a very narrow part of the overall trial process. And one of the gaps in the reform is that the working group recognised that there were going to be significant consequential effects to the broader evolution of a piece of litigation. We've touched quite in detail about the joint statement of facts, and that was one of the 5 recommendations the first working group report put before themselves for further consideration. But when they drafted the practice direction, that they ducked the issue by saying, well, we're doing a practice direction on witness statements, so it's not appropriate to draft any provisions about joint statements. But in our mind, they remain a good thing. Well, great, thanks. How are we going to deal with this? It's not in any of the court guides. Are we going to have to introduce that into a CMC order? The current rules are silent. More fundamentally, the working group anticipated that this may have quite a serious knock-on effect as to the balance of how trials themselves are conducted. Certainly for my part, I've grown up in an era where the commercial court, in particular, has looked for parties to rather pare back openings. It's supposed to be short, uncontroversial, really just giving the big picture identity to the judge of what this dispute is about, and then let's get on to the first witness, please, by lunchtime on day 1. Now, again, the working group anticipated that we may be going back the other way. We may be going to a point where we've got, yes, lengthier skeletons, yes, more detailed chronologies, a greater onus on the judge, and we should timetable in more anticipated pre-reading time for the judges to have allocated to them, because if we don't give them the reading time, listing won't find it for them out of the generosity of their heart. But also we may find that lengthy openings are back on the table now, as we have to take the judges through what are far more of the key chronological documents. If we're going to look at the documents as the evidence of primary fact, then the judges need to know those documents up front. They want to take away cross-examination about the effect of documents out of cross-examination and put that into submission. So again, we've got to think about, well, are we going to flag those points in the opening, or certainly we're going to have to deal with them at much greater length in the closings. So the balance of a trial between the live witness aspect of it and the more submission-based aspects of the trial, I foresee as being something that is going to be part of the evolution as these reforms bed in. But having given us such detailed guidance on one area, we're now left slightly foundering and reliant on our opponents to be of the same mindset as to the overall balance of a trial. So we may need more case management there as well. And
it would be ironic, wouldn't it, that one of the things that kicked off all these reforms was the BCCI case and the openings that went on for days and days and days, if not months, and that in actual fact we come back full circle and end up with very extended opening statements, at which point then the whole thing will start again. I'm going to open it up to the floor, but before I do so, just one last question for the panel. I was reading about the Maxwell trial this weekend in the paper, and one of the things I noticed that they were going to have experts on false witness testimony, which I'm sure you've probably read about, and the idea being that actually oral evidence isn't really worth the paper it's written on because it's generally tainted by what the witness has seen or may have heard. And I'd just be interested, just a quick soundbite from all of you as to what effect, if anything, that's going to, our new reforms are going to have on that.
Well, if I could kick off that, I think the takeaway from the reforms is we have to really only deploy witness evidence if it is absolutely necessary. Don't think of it as the default, but think of it as the rare exception.
John?
Yeah, I think I echo what Henry's just said. I think witness statements are much shorter now. You're not putting your client in any risk with the witness statements. You're focusing just on things that are not covered in documents. So just trying to protect them from any risk.
And Daniel?
Yeah, I think that these rules are actually the culmination of a lot of research over recent years into the fallibility of human memory and judicial deployment of that. And the strong steer has effectively been in judgments that documents are king and witness recollection is fallible, and therefore don't place that much reliance on your witness's recollection unless you've got reason to actually establish that it's completely clear in its relatively recent recollection.
Yeah, it's odd, isn't it? Because in one sense, you could be saying we're moving more towards a civilian inquisitorial system rather than the adversarial common law system that we've grown up with. But that's for another day. We have a few minutes for questions. I don't know how we're dealing with questions. I think Mark's going to deal with questions, and I'm going to deflect any curved balls to my co-panelists. Over to Mark. You're muted, Mark.
I think we're okay. There's one question that's come through on Slido for the panel. Does the panel have any experience of dealing with these statements when the witness is also the client, and the different docs and info seen in these roles?
Oh, I think that's one for John.
And I think that's precisely the issue I sort of touched on, where you've got a client who is the person who identified the issue in the first place, has come to the lawyers, has looked at it, possibly investigated it internally, done a search for documents, gone to the lawyers to get advice on it. So yes, and I think that presents an issue when you're trying to list out the documents, which inevitably a lot of that work will have been done before you have been instructed. So what I think one of the things that I've certainly seen where that's happened is that there is this opening paragraph in your witness statement which says, I am the client. I have been looking at this for X number of years. I have looked at a variety of documents. I can't list them all out, but they have all been disclosed. And I think that's the only way to manage it, but we'll have to wait and see how judges react to that. But I think certainly the interim hearings that we've had in relation to this practice direction so far have shown a flexibility by the judiciary as to how they approach this rather than adopting a very strict line with it.
Yes, there was a decision of last month in the TCC. Mrs. Justice O'Farrell had this point in front of her, and she showed a recognition that there would be in that client-witness position between the documents that you're looking at for the purpose of the exercise of putting together the witness statement versus everything you've seen since you first went to the client at the solicitors at the pre-action stage. So there certainly seems a willingness. It doesn't mean that there's a very fine divide, but a willingness to see that those things are different.
I think there's a question over there.
Hi.
Do you want to introduce yourself?
Introduce myself. I'm Maxine Mossman from Clifford Chance. I have a question about witness statements. And do you have any experience of what the judges are doing when a party just doesn't comply at all with the new rules? You know, are the judges going to strike out, or are they going to tell the party to go away and try again? And I should say this is not just theory. I had a case recently where the other side simply disregarded every single part of the rules. So it wasn't even like they just failed to sign the certificate of compliance. They were just really, really poor statements. And, you know, you had witnesses talking about documents they weren't even party to at the time. And I was just interested to know what you think the judges are actually going to do to give some teeth to this.
John?
I haven't seen that yet. There have been a couple of decisions whereby there have been challenges from the other side as to non-compliance with a particular part, and the judiciary have been quite flexible in that regard. But I think the message that's been sent through in those cases is they have tried to comply with it. If you're fundamentally not complying with it, I would expect a judiciary, if you get the right judge, will send them back with their tail between their legs and possibly with serious consequences to it. Because if in that situation, Maxine, I think they really are looking at they're being professionally negligent in short. So.
But in terms of procedure, is that going to be dealt with in PTRs, or will you have separate witness statement bust-ups?
I would expect that there's lots of defendants or other side claimants or defendants, who's on the other side of it, who would be issuing an application for strikeout of the evidence and then putting them under real pressure as to how they pursue their case.
We are flashing, but Henry, have you got a...
Well, back to the point, I foresee there's going to be a greater incidence of PTRs probably generated by this reform, because you don't want to wait till the trial, because by that stage the judge has seen the evidence written down, and if they strike it out, then probably that horse is bolted. But the rules make very clear there's scope for applications, and there's a couple of cases where applications have already been before the courts, and I'm sure the courts aren't going to encourage this into a new satellite litigation area, but if they don't show early on that they're taking this seriously, I think they will fear that the wrong message is going out, and if lip service is only being paid, then the whole reforms will go to nowhere.
And Daniel, would you just like a last word on that before we sign off?
I very much echo what Henry says, and I think in terms of how much leeway the courts will give in the situation you described, for example, I think that may also depend on how much pressure that's putting on the trial timetable and if it's affecting the trial. And I think the courts won't be reluctant to invoke nuclear options if, in worst case scenario, allowing them to serve fresh evidence compliant with the rules is going to jeopardise the trial timetable, because that's the thing that courts hate the most at the moment, and for understandable reasons.
Good. Well, thank you. Thank you very much to you, and thank you very much to my brilliant panel this morning. And I think do I pass you over to Mark?
Thanks very much.
Thank you very much.